What is our policy on late or non-paying tenants? I think sometimes even a well-qualified tenant can have things go wrong that will affect their ability to meet their obligations. As much as I can understand a tenant's predicament, it's important to remember that we represent the interests of the owner and we take a very firm stand on rental obligations. Rent is due on the first day of the month. If we've not received the rent by the sixth day of the month, we issue a 5-day pay or quit notice to the tenant, and we also copy the owner so that they are aware that a possible problem may exist. We will also at that point attempt to contact the tenant to find out what's going on and just make sure it's just not an oversight or the check is maybe really lost in the mail. The unlawful detainer. If we have not received the rent by the 12th day of the month, or sometimes the 14th depending on the weekends, we will file an unlawful detainer with the circuit court of the municipality in which the property is located. And again, depending on that municipality, our court date will generally be about 3 weeks from the filing date. When we go to court, and if we have all of our documentation in proper order and can argue and any objection that the tenant may have, and we are awarded the judgment, the judge will normally give the tenants 10 days to voluntarily vacate the premises. If the tenant refuses to vacate the property within the 10-day period granted by the judge, we will have to file a writ of possession with the Sheriff's Department. Depending upon the department's schedule, the writ of possession is normally exercised within 7 to 10 days of filing. On the day that the eviction takes place, the sheriff will accompany us and a locksmith to the premises. The sheriff's deputy will escort the tenant out of the building and the locksmith will change the locks. From that point, the evicted tenant will have 24 hours under our direct supervision to remove their possessions from the house. Any items left in the house longer than 24 hours become the property of the owner and may be sold or disposed of as the owner sees fit. Any security deposit that we hold will be dispersed to the owner to offset back rent and repairs. If the owner chooses to take further action against the tenant through garnishment proceedings, they will have to engage the service of a legal professional. It should be noted here too that sometimes when we get an unlawful detainer, we can actually hold that document or that judgment for up to a year from the date of the judgment. In the event that a tenant did actually have some catastrophic failing that went wrong with them and they were able to bring their rent current and resolve the issue, the owner would have the option of telling us not to exercise the writ and to just hold it and see what the tenant does over the next year. If the tenant gets behind in the following year again, we can just go down and file the writ of possession and have the tenant out within 10 days. So just because we get just because we get the judgment for a writ of possession does not automatically mean that the tenant will be evicted. If you have any more questions about this topic or any other aspects of property management, I wish you'd give me a call. I'll be happy to help you in any way possible. My name's Lynn Albert Smith. I'm the associate broker and Director of Business Development for JJC Management and Holdings. You can call me directly at 757-237-6786. Please feel free to call our office at 757-213-6990 or email me at lasmith7146@gmail.com. I am a licensed agent and broker in Virginia, and our offices are located at 3207 Churchland Boulevard in Chesapeake, Virginia 23321. Thanks so much for listening.